This is part 2 of civil procedures. We're going to start with personal jurisdiction. Personal jurisdiction is power over the person and or the property. It's governed by state statutes, meaning the federal court does not have independent statutes regulating personal jurisdiction. The federal court has state court personal jurisdiction. You must have, to hear a case in federal court, you must have personal jurisdiction as well as subject matter jurisdiction. There are 3 types of personal jurisdiction: in personam, which is personal jurisdiction; in rem jurisdiction, which is jurisdiction over real and or personal property; and quasi in rem jurisdiction, which is also jurisdiction over real and or personal property. The difference between in rem and quasi in rem is simple. Although they didn't make it simple in law school, it's simple. In rem personal jurisdiction is jurisdiction, again, over real and or personal property, but an in rem action extinguishes all rights to all parties in and of the property, whether those parties are named or not. This is considered an eminent domain action. Whether the party is named or not in the action, their rights are extinguished. A quasi-in rem action is, again, real or personal property. However, this action only extinguishes the rights of the named defendants. Personal jurisdiction in personam, again, this is personal jurisdiction. This is jurisdiction over the individual. There are ways to get personal jurisdiction. The defendant is within the state, domiciled in the state, voluntarily consents to court jurisdiction. If you are getting jurisdiction over the defendant because they are within the state, the defendant must be within the state voluntarily and be served. And the court has jurisdiction over the defendant. The defendant cannot be simply passing through the state or have been brought into the state fraudulently. Looking at personal jurisdiction over the defendant where they're domiciled, this is where the defendant intends to make the state their home. This can be seasonal, living in Arizona and Minnesota partially. Looking at consent to personal jurisdiction, if you do not challenge jurisdiction in a response of pleading, your challenge to jurisdiction is waived and you have effectively consented to jurisdiction. Personal jurisdiction and long-arm statutes. This is a statute authorizing jurisdiction over non-residents, such as a result of an activity, that non-resident has some activity or causes some action within the state. Personal jurisdiction and the concept of attachment. Now, this is important. If the defendant owns property within the state, personal jurisdiction attaches to the defendant through the property. If there is no attachment, meaning the defendant does not own property within the state, then the defendant must have minimum contacts with the state, and that is from Erie. Again, continuing with minimum contacts, they are required for due process purposes. Again, the defendant does not have any property within the forum or the state, so they must have some minimum contacts with the state to be subject to personal jurisdiction. And these contacts must be such that maintenance of the action, this is some key verbiage, minimum contacts must be such that maintenance of the action does not offend traditional notions of fair play and substantial justice. That's from International Shoe. Purposeful availment must be purposeful and substantial, such that jurisdiction should be foreseeable. Putting a product in the stream of Congress, courts are split as to whether this amounts to purposeful availment, where the action arises out of contact with the jurisdiction. The level of contact may be slight, can be one instance, such as the instance that caused the harm. You're passing through the jurisdiction, cause a car accident. That's enough. Looking at fair play and substantial justice, you must consider the forum interest in the action and the burden on the defendant in appearing in the forum, and the state interest in efficient resolution of the action. Looking at personal jurisdiction in personam for corporations, Now, this is a little confusing as well. They are only a resident of the state of incorporation, that is for personal jurisdiction purposes. Otherwise, look to minimum contacts. Considering websites, look to the degree of interactivity between the site and the state. If it's passive versus integral to the business, passive, less likely to confer personal jurisdiction, more integral, more likely to confer personal jurisdiction. As stated earlier, the court must have personal jurisdiction and subject matter jurisdiction. So what they have, the corporation must have minimum contacts with the jurisdiction. That goes to the personal jurisdiction. Looking at diversity, that goes to the subject matter jurisdiction. Do not confuse the two. Where I say in personal jurisdiction, corporations are only the resident of the state of incorporation. Do not confuse that with looking at citizenship under diversity and the nerve center test. A bit more about personal jurisdiction in rem. Again, this is against real and or personal property. It affects and or extinguishes all parties' interests in the property. Examples: eminent domain. Due process requirements of notice must be reasonably calculated. Personal jurisdiction and quasi in rem, again against real and or personal property, affects and or extinguishes only interests of the named defendant. Due process requirements, property in the jurisdiction, and minimum contacts therewith. Due process generally requires notice that is reasonably calculated under all circumstances to apprise parties of the action and afford them an opportunity to present objections. That's from Mullane, M-U-L-L-A-N-E. Moving on to venue. Venue is the proper forum. There are a couple of different types of action when discussing venue. One is a local action, and that is a property-based action and or dispute. Another one is a transitory action, and that is an events-based action. So you have local action, transitory action. If it's property-based, it's local action. If it's events-based, like a car accident, then it's a transitory action. Venue is proper where a substantial part of events occurred and or property is located, or where any defendant resides if all defendants reside in the same state of district. Business entities, venue is proper where they are subject to personal jurisdiction. Venue and removal from state court. Again, remember that removal is the right of the defendant only. Venue and removal from state court. Venue is proper in the district where the state court action was brought. It is immaterial that venue would have been improper there originally, and that concludes Part 2 of Civil Procedures.